Hi, my name is Kyle Ingram, and I am presenting to you the Federal Employee EEO process. This is a quick guide to how federal employees go through the EEO process at their particular agencies. So first, I want to talk about the agency investigation process. First, there's a discriminatory event. Within 45 days of that discriminatory event, you want to make contact with an EEO counselor. If you don't know who your EEO counselor is, just ask. There are people who do this as their job. Usually it's part-time. But if you do not make contact within 45 days, your claim may be gone forever. Once the EEO counselor has been contacted and you've filed what's called an informal complaint, the EEO counselor will either investigate and report, or you can choose, on the other hand, EEO mediation. After the EEO counselor produces either the report and investigation or conducts the mediation, she will issue you a letter that gives you 15 days to file a formal complaint. You have to fill this out within 15 days and return it to the EEO counselor, and then the agency will appoint an investigator to talk to witnesses, to talk to the responsible management officials. So the agency process, at the end of it, when the investigation is done, you get what's called a report of investigation, or an ROI. This includes documents, affidavits. There are other aspects of the ROI which are helpful not only to you but to attorneys. The final thing that the ROI gives you is 30 days to file for an administrative judge. So it will be a separate letter that comes with your ROI that gives you the opportunity to file for an administrative judge. But if you don't request an administrative judge, you're not going to get the administrative judge process. So going back to the outline here, once the ROI has been issued, that means that you have the opportunity to get an EEOC administrative judge assigned. If you get the judge assigned, that starts the EEOC hearing process. Now, it may take months, sometimes more than a year, to get an administrative judge assigned, depending on where you are in the country. Once the EEOC administrative judge issues an order that directs the parties to conduct discovery, you and the agency will go into a period of time during which you get to ask for documents, depositions, and other things from the agency. After discovery comes summary judgment, and these things have to be understood together. In discovery, you have the opportunity to get documents through document requests, propound interrogatories to the agency, which means you give them a set of questions that they legally are required to answer under oath. You can ask them to admit to certain facts, called admissions, and you can ask for depositions of particular witnesses. Summary judgment, on the other hand, is where you present the evidence that you get in discovery to a judge. At that point, you are telling the judge, based on the evidence that we have in front of us today, you should allow this to go to a hearing because there is a genuine issue that requires a hearing. At the summary judgment stage, the administrative judge has an opportunity to dismiss claims that can't be supported. A judge will only hold a hearing for claims that have proper evidentiary support. What that support is depends entirely on the claims. But if there is no genuine issue that requires going to a hearing, the judge will dismiss the claim or claims. At the hearing stage, the agency and you will both be able to present witnesses and cross-examine witnesses in front of the judge, and then the judge will determine, based on all of the evidence available at that hearing, what has occurred and whether or not that constitutes discrimination. So going back to our process, once you've gotten past summary judgment, you go to hearing, and then the judge will issue a judgment based on that evidence. The next step is that the agency has then 40 days to either implement that decision or to file an appeal. On the other hand, if the EEOC administrative judge has decided against the employee, then the employee has to wait to see what the final agency decision is. Once that final agency decision has been issued, there are a couple of choices that an employee has. The employee, within 30 days, may appeal to the EEOC. If the agency does not issue a final agency decision at all, under the regulations, the EEOC hearing judge's decision becomes the final agency decision. The other thing that an employee can do is file action in federal court. That 90 days is critical. If you have a letter that says you need to file in court within 90 days, you should take that very seriously. If you file your complaint beyond 90 days from when you receive that document, you may be precluded from any recovery at all. This process can take months, years, and typically takes around 2 years in my experience. Nothing that I've said here is legal advice specifically for you. If you think you've been the victim of discrimination, you should consult with an attorney who can talk to you about the facts of your case. Many attorneys will meet with individuals for free or for a low cost, and you should definitely explore your options.